Well, hello everyone, and welcome back to Aj111 Criminal Procedure. This is going to be the part 2 lecture on chapter 4, Stop and Frisk. And if you remember, we left off getting ready to talk a little bit about informants and hearsay. So let's go ahead and jump right into the second half of our lecture. So, reasonable suspicion may be based on a police officers' direct observations or on information from an informant, a victim, eyewitnesses, or even a police bulletin. So information that law enforcement puts out to inform other law enforcement officers on what's happening around in the area by way of crimes and suspects, etc. Now, information that is obtained in this secondhand fashion, if you will, rather than through a police officer's direct observation, is called a hearsay report or hearsay. So to kind of like re-summarize again, secondhand information as opposed to direct observation is considered hearsay. Now, the classic example that I can give you is a bloody victim who flags down a squad car and describes the identity of his or her attacker. And in other circumstances, the police understandably may have less confidence in hearsay information. So consider this. Consider a police officer who is informed by an anonymous phone caller that there is a person wearing a baseball cap selling drugs on a street corner across from an elementary school. Would it make a difference if the caller stated that the person, the drug dealer, was armed? Is this enough? Is hearsay information enough? It's secondhand. It's not something that you observe. Go back to the first classic example. If somebody is assaulted, we talked about the bloody victim who flags down a police officer, describes the identity of the individual that did the attack. You didn't see that. It's somebody telling you that. So technically, by definition, that is in fact hearsay. Is that enough to constitute that burden of reasonable suspicion? Does that kind of make sense? And the drug dealer aspect, somebody that someone came up and said they saw somebody selling drugs, would that be enough? But what if they said they're armed? Does that add another level of public safety, which might make that hearsay information a little bit more viable? So how does all of that work? Well, let's look at a couple of cases that talk a little bit about hearsay. So again, we kind of already went over this particular example, but let's look at the Adams versus Williams case. This is a 1972 case. I have a link to the court case if you want to look at it. But here, the U.S. Supreme Court, confronted with the question of whether reasonable suspicion may be based on the hearsay report of an informant, something the officer didn't see. It's something that they were told. The court held in this case, and you can go look at these, you can look these cases up, that the tip possessed sufficient, what they call indicia of reliability, or you can say it's indicia, depending upon how you pronounce it. Anyway, there was enough information to justify the officer acting on the informant's tip. And the informant was known to the officer and had provided information in the past. So in this case, you basically have an informant that has been used before or that has provided good information before, and therefore, in that case, the court held that this particular tip possessed that sufficient indicia of reliability, okay, to justify the officer acting on the person's tip. Okay, because there was a little more credibility to it. And again, you can look at the individual case if you want to. So the Supreme Court again held the officer properly relied on a credible informant, one that you've used before, and the police also may justifiably rely on information provided by a victim of a street crime. So if a victim gives you information because they've been the victim of a crime, typically there's no reason for them to lie. It doesn't mean it never happens, but what the court is saying here, that we can use credible informant information just as, and we can also use information from a victim because they typically don't lie about being victimized. Now, however, there are some tips completely lacking in that indicia of reliability, and those particular types would in fact require a little bit more investigation or even corroboration, if you will, before a forcible stop could be made in that particular case. So that was the Adams versus Williams case. And now let's take a look at the Alabama versus White case. So again, I have a link to the case law if you'd like to look at it. This is a 1990 case. And in this particular case, the Supreme Court observed in White versus Adams that reasonable suspicion is a less demanding standard than probable cause, which we know that to be true. So in this case, this Alabama versus White case, the court then applied the totality of circumstances test that stressed two critical factors as it relates to informants and hearsay. The first factor is that the informant was reliable or trustworthy, which means that they would have had to have given you information before. And second, that what is the basis of his or her knowledge, meaning how did they come up with that particular information? So here in this particular case, I'll give you a little bit of background and you can kind of think about it. Officer Davis of the Montgomery, Alabama Police Department received an anonymous phone call stating that Vanessa White would be leaving a particular address at an apartment complex in a brown Plymouth station wagon with a right tail light lens broken, and that she would be going to a motel, and that she would be in possession of roughly an ounce of cocaine inside of a brown attaché case or a briefcase. Now, first of all, when you think about that, it's very factual, very detailed information. So when you're talking about trustworthy, reliable, etc., or even the basis, how do they know all this? Well, they might be very close to the criminals themselves, so they have all of this factual information. So again, things to consider. So they followed White as she headed towards the motel and pulled her over before she reached the motel. Then the officers seized a locked brown attaché case or a briefcase that was in the car, received consent from White to open the case, and they found marijuana. Now the question is, did the police have reasonable suspicion to stop White? And so think about it. I'm just going to kind of give you a second here to kind of think about that. Was there enough? What was the basis of the person's knowledge? Well, it must have been pretty knowledgeable. Was the information kind of reliable? Okay. Now, a couple of things that they talked about in this particular case is that, again, the court used this totality of circumstance test that asked those two considerations. First, is the informant reliable? And second, what was the basis of the knowledge? Now, in this instance, the police knew nothing about the informant, and there was no basis to determine whether the anonymous tip satisfied either of these particular conditions. However, the Supreme Court nevertheless ruled that the police possessed reasonable suspicion to stop White based on their corroboration of the facts that were provided by the informant. So, I mean, these cases sometimes can be a little technical and a little gray. On one hand, the police were unable to verify the name of the woman leaving the building, the apartment from which she left, or whether she was carrying a brown case to start with. But on the other hand, The informant gave them a number of very accurate predictions, and this included the building from which the defendant left, the general time frame of departure, the type of the car, and the driver's destination. And the court, again, in particular, stressed that because only a small number of people who are generally privy to an individual's itinerary, it is reasonable for police to believe that a person with access to this kind of information is likely to also have access to reliable information about this person's illegal activity. So they're talking about credibility and they're talking about specificity. So again, the court sided on the side of the officers in this particular case. And then another case just to quickly look at would be Navarrete versus California. So this is a little more contemporary case. It's 2014, and I have a link there for you to look at. But here, the Supreme Court once again addressed the circumstances in which an anonymous informant's tip constitutes reasonable suspicion. So, I mean, the facts of the case are an anonymous informant at about 3:47 in the morning called 911 reporting that a silver Ford 150 pickup with a license plate, and you don't need the plate just for context here, had basically ran her off the road. And that information was broadcast to CHP officers, and at about 4 o'clock p.m., an officer spotted and began to follow the vehicle because the plates matched. And he pulled over 5 minutes later based on suspicion of drunk driving. And upon approaching the pickup, the officer smelled marijuana, and a search of the truck resulted in a seizure of 30 pounds of marijuana. And the driver, Lorenzo Prado Navarrete, and passenger Jose Prado Navarrete were both arrested for transportation. Now, this is, again, these court decisions aren't always a 9-0. So here, in a 5-4, very close decision, the court held that under the totality of the circumstances, we've heard that word again, the indicia of reliability, that amount of information was sufficient to provide the officer with reasonable suspicion to execute the traffic stop. So again, some very kind of interesting court cases that we've had a chance to look at. And when we talk a little bit more about hearsay and informants, okay, Justice Thomas basically first concluded that the informant's tip in the prior case was reliable, but there are some certain circumstances that we want to look at as it relates to what we call reliability or basis of knowledge. And we're going to go through all of that here. But in all of these cases that we've kind of gone over, the Supreme Court in Adams versus Williams, in Alabama versus White, and Navarrete versus California, they established that a police officer under certain circumstances, okay, and that's what we're going to talk about, these certain circumstances, may rely on an informant's tip to establish reasonable suspicion. So the first one is reliability. And here the judge asks whether the informant is known to the officer and considers whether the informant has been accurate in the past. The court will also consider whether there is a statute that makes it a crime to make a false complaint and whether the information personally approached or whether the informant, personally approached the police. The next one would be the basis of knowledge. Now remember, we're talking about these certain circumstances. So the judge in this case also asks how the informant has obtained the information. An informant with firsthand knowledge of criminal activity should be able to provide very detailed information. So it's not just some secondhand information that they heard that they're passing on, making it like double hearsay. It's information that they have observed firsthand, if you will. Next would be what we call contemporaneous report, a firsthand tip made close to the event under the influence of emotion and excitement without time for reflection has additional credibility. So let's say if you were to pull up to somebody waving very quickly and you see that they've been assaulted and they go, officer, it's so-and-so, he went that way. I mean, there's no really time to make up a lie is kind of what the court is saying here. It's a firsthand tip so close to when something happened that because of their emotions and excitement, there's no time to really reflect on or to lie about it. So does that kind of make sense? It's very fast and ongoing. The next would be police corroboration. A tip that lacks these three indicia of reliability may be relied on when corroborated in essential details by police. Most important is the informant's ability to predict a suspect's future conduct. So if we can corroborate some of the information, we can make that credible, and therefore it'll be okay. Next is ongoing dangerous act. A tip is given greater weight when involving a dangerous ongoing act. And then finally would be the totality of circumstances. And here is where the judge strikes that balance. The less reliable the informant, the more the court is going to kind of insist that the information is in the position to provide detailed information. So that informant needs to be able to provide detailed information, the less reliable that particular person is. A tip that is thought to lack that indicia of reliability may be strengthened by corroboration, by the fact that the informant came forward personally, and by a criminal statute that punishes an individual for basically false criminal reports or lying. So if they knew that they were going to get in trouble for filing a false report, why would they actually do it? So all of these things fall under the umbrella of the totality of circumstances. So hearsay is kind of a tough thing, but it's hopefully this kind of made it a little bit easier. And to kind of break it down a little bit, I've formulated kind of a legal equation for you to look at. So when we look at this, on the left you have the police reliance on an informant's tip. First you have the reliability of the informant plus the basis of the informant's knowledge plus the corroboration of the essential details if we are lacking that indicia of reliability, and it's all going to be gauged on the totality of the circumstances. So that's kind of your legal equation describing informants and hearsay. Okay, now let's move on to another part of stop and frisk, and this is the part that falls under drug courier profiles. Now, law enforcement officers have developed profiles, and I'll stop there. You're probably going, hey, wait, Professor, I thought we weren't allowed to profile. Well, you're wrong. We are. There's a couple of case laws that tell us that we can profile. We can't just use one particular thing. And think about what that will be, and we'll get to that. But law enforcement officers have developed profiles to assist in detecting and investigating criminal conduct. Now, an officer relying on a profile compares a person's actions to be the behavior pattern in the profile. So what we're supposed to do is we can add in some characteristics of an individual on top of the actions, but you just can't see, you just can't profile on, let's say, race by itself. But it can be other actions that add in there. So hopefully that kind of makes sense. Typically, these are based on an analysis of the behavior of people who have been arrested in the past for crimes such as, let's say, hijacking and even illegal immigration or drug smuggling and things like that. And we're going to talk about courier profiles. So, a match between a person's pattern of activity and the profile is thought to provide reasonable suspicion. So hopefully that kind of makes sense. And there's a couple of cases that talk a little bit about that. Now, we know that it's difficult because it's difficult because innocent individuals may at times display some of the characteristics that we're going to talk about. So we have to be very, very careful when we do this. But again, if you can formulate a match between a person's pattern of activity and the profile itself, it is thought to provide reasonable suspicion. Now, first profiles were actually developed to detect and track illegal narcotics traffickers. And primary credit for this is given to a DEA agent by the name of Paul Marconi, who worked out of the Atlanta office. And here I have a couple of photographs that you can see where there's different ways that couriers will hide some of their things. This particular courier has a fake belly. So it is a female, and she's basically has all of the drugs stuffed under this fake belly. And she is professing, of course, to be pregnant. And then down here, you can see that a lot of times the couriers will basically wrap the drugs to their body, down their legs, around their waist, sometime even around their chest. And they'll wear kind of a bulkier sweatpants or clothing over the top of it in hopes that they will not be detected as they go through the airport and try to board the plane or something like that. Now, part of the Marconi drug courier profile, it consisted of basically 7 primary characteristics. And we're going to talk about each one of those just briefly. The first would be, and again, we're specifically focusing here on drug couriers. So number 1, arriving from or departing to an identified source city. Colombia, Argentina, Venezuela, parts of Mexico. Okay, places that have been characterized or identified as a source city for a particular type of drug. Okay. Number 2, carrying little or no luggage or a large quantity of empty luggage. Now again, each one of these individually may not amount to anything, but as you start to put them all together and you see a pattern, these fall underneath the pattern of these characteristics. Number 3, having an unusual itinerary, such as a very quick turnaround time for a super lengthy flight. So 6-7 hour flight and then half an hour turnaround time. Doesn't mean that doesn't happen, because it does. And I've been on those where the turnaround time has been very, very close. So again, it's just something to look at. It's a characteristic. The next one would be using an alias name. Next would be carrying an unusually large amount of money, currency. Next would be purchasing airline tickets with small denominations of currency and paying cash. And then finally would be displaying very, very unusual nervousness. Now, there are a couple of different secondary characteristics, and almost exclusively using public transportation or taxi cabs, coming to and from the airport, immediately making a telephone call after deplaning. But again, some of us do this. 3, leaving a false or fictitious call back telephone number with the airline. Or finally, excessively frequent travel to a source or distribution city. Now remember, part of the difficulty in this is that innocent individuals may in fact display several of these characteristics. Some critics complain that the focus on source or distribution cities also tends to single out certain ethnic and racial minorities, which might be true. And on the other hand, profiles merely recognize that we rely on past experience to make judgments on a daily basis. In the case of drug courier profiles, there is a indication that the profiles are pretty reasonably accurate. Data from the Detroit airport, as a matter of fact, cited by Justice Lewis Powell Jr. in a 1980 Supreme Court decision, indicated that during a period of 18 months, Drug Enforcement Administration agents, or DEA agents, relying on a drug courier profile searched 141 persons in 96 encounters, and controlled substances or drugs were discovered in 77 of those encounters, leading to the arrest of 122 people. And the case that covers that is United States versus Mendenhall. The courts have avoided basically weighing in on the debate over the accuracy of profiles, and generally do not give particular weight to the claim that an individual fits a profile. Judges instead will ask whether the combination of factors, remember I told you not just one thing, it needs to be more, identified in the profile constitutes reasonable suspicion. And in some instances, courts have found reasonable suspicion where law enforcement agents have supplemented the profile with other or additional observations. So through all of this, 3 points kind of emerge concerning the reliance of profiles, if you will. The first is reasonable suspicion. So courts will examine profiles to determine the factors. Next would be the suspect's conduct. Reasonable suspicion must be based on evidence of an individual's specific actions. And then finally, what we call non-suspicious conduct. A pattern of conduct that is innocent based on the totality of circumstances. And to give you a little bit more on that, a pattern of conduct that is innocent or characteristic of a large number of individuals may contribute to a finding of reasonable suspicion based on the totality of the circumstances. And these facts alone are not sufficient to constitute reasonable suspicion. So, with that being said, let's look at another legal equation before we start to get towards the end of our lecture here. And we're going to talk, again, this is the seizure of a person based on a profile. So here you have to the left the seizure of the individual over here, and it's equal to, the courts will not automatically find reasonable suspicion based on a profile, because we're going to add in the suspect action or actions or characteristic of an individual engaged in illegal activity. And again, it's going to be viewed on the totality of all of the circumstances. What about race then and reasonable suspicion? So we've talked about courier profiles. We've talked about informants and hearsay. Well, let's discuss a little bit about race and reasonable suspicion. So the claim that, or the claim that is made that the police and law enforcement officials engage in racial profiling or stopping people because of their race, ethnicity, gender, or other characteristics rather than their actions. So this is the claim that's being made. To solely rely on race to stop someone, really, it's contrary, which means it goes against the 5th and the 14th Amendment. Okay? There are a number of general points to keep in mind concerning whether the police may consider race in initiating a Terry stop. So let's look at some of these different points, and then we'll take a look at a particular case. So let's look at sole factor. An individual may not be stopped when the only reason for his or her seizure is race, ethnicity, gender, or religion. Number 2, and it's kind of an interesting word if you haven't heard it before, it's called incongruity. And this means an individual may not be stopped based on the fact he or she doesn't, quote, belong in the neighborhood, end quote. And hopefully that makes sense. So there was a case that really backs this up. There was a case called State versus Barber out of Washington in 1992. And it said basically that an individual may not be stopped based on the fact that he or she does not belong in a neighborhood. And the Washington Supreme Court here noted that racial incongruity should never constitute a finding of reasonable suspicion of criminal behavior. Distinctions between citizens solely because of their ancestry are what they call odious to a free people whose institutions are grounded upon the doctrine of equality. So when, and it wouldn't be the first time that I've heard of someone being stopped in an area because, well, they just don't belong here. So that can't be the only reason. There needs to be other factors. And consider the 2 pictures again, okay, as we look at some kind of things that we're looking at as far as bias or whatever. Next would be identifications. Race may be considered as a factor in determining whether there is reasonable suspicion, okay? Because think about it. What if the description of the suspect is known? Can race now play a role? Can it be a relevant factor? If the crime of the, if the robbery is committed by a white male, you're going to be looking for white males because that's the information that you have. So we're saying basically that in some instances, okay, there can be a determining factor when it comes to race. And one of them would be the description of an individual. Okay, so and I gave you some pictures to kind of go along with that. What about profiles? Race, ethnicity, or some other description may be considered, but as one of several factors. And this is the United States versus Weaver case, 1992. And it is a case that's listed in your textbook on page 101. So, and in this particular case, it deals with Border Patrol and DEA agents. So, I threw this in there as kind of an interesting tidbit. And this was an article in 2015 that's basically, the title is University of Minnesota to Stop Using Race in Crime Alert Suspect Description. And here the administration of this place, of the college, reverses course and now views a suspect's race as too general of a descriptive characteristic to be useful. And I put the article in there for you to look at. But think about that from a law enforcement perspective. If somebody says that I was robbed by this type of a person, I believe them to be this race, this tall, this old, with this kind of clothing, aren't they all descriptors? So I'm not saying this is a horrible thing, but I'm saying that it's not really the best way, in a sense that you are allowed to use race in certain circumstances. Okay, so I'm just kind of enough of that, but I thought I would throw that in there so you could see how things are a little bit different. So just quickly looking at the legal equation as it relates to race. So you have on the left race, ethnicity, gender, and other factors. And in the middle we have it equals to a Terry stop may not be based on race, ethnicity, gender, or other constitutionally suspect personal characteristics or the incongruity of an individual's presence in a neighborhood, meaning like they don't belong. Along with race, ethnicity, and other characteristics may be considered when they are coupled with other factors. All right, now we're going to finish up here with talking about the scope and the duration of Terry stops, and that'll take us probably through the end of our lecture. So, the Terry stop and frisk is a limited intrusion to investigate and to detect crime. And the emphasis here is on limited intrusion. Now, an investigative stop must be temporary and last no longer than necessary. Now, I know that that's a lot of legalese language, and you're probably saying, well, God, how long is that? So, I mean, a traffic ticket would be, if I stopped you for speeding, it would be basically as long as it would take me to kind of write the citation. So again, this Terry stop and frisk is a limited intrusion to investigate and detect crime. And you recall from earlier conversation that because Terry seizures are for a narrow purpose and involve a limited restraint on freedom, law enforcement then is required to satisfy a lesser standard of proof or reasonable suspicion than is required for an arrest, which actually needs, and we know what it needs, probable cause. And it is a basic constitutional principle that law enforcement officials may interfere with your freedom and privacy only to the extent required to accomplish a purpose. Okay, so no longer than necessary. And we've also found some challenges as it relates to the scope and duration of Terry stops. So as the Supreme Court observed, Terry stops warrant a limited intrusion on the personal security of an individual. An investigative detention must be temporary and last no longer than is necessary to fulfill the purpose of the stop. And as a result, then, a Terry stop may be challenged as unlawful when a suspect is treated as if he or she is being subjected to a higher level of burden or a probable cause arrest rather than to a reasonable suspicion stop. And this inquiry typically focuses on three areas. The first would be movement. A Terry stop does not permit involuntary or significant movement unless safety or security is an issue. You cannot be involuntarily transported to the police department, if that makes sense. The next would be the length of detention. When it comes to a Terry stop must be for a limited duration. You cannot be subjected to a lengthy detention or interrogation. And the last one is intrusiveness. The police are to employ the least intrusive methods reasonably available to them to investigate the suspected criminal activity under the circumstances and to basically interfere as little as possible with your freedom. And a suspect ordinarily may not be detained by force, handcuffed, or locked in a patrol car. In other words, the justification for the stop, the Terry stop, defines the scope, the limited movement and intrusiveness, and duration, or the limited time of the stop. A probable cause stop, in contrast, permits an arrest that may result in the basically taking into custody of an individual for an extended period while awaiting trial. So hopefully those challenges, you kind of understand those as we went through them. And as far as the legal question goes, we can kind of look at how this is put together. So we have the Terry stop here, may not be carried out in the unreasonable fashion, and you have the three things we talked about: the movement, the length of detention, and the investigative techniques. All right, finally, automobiles. Many law enforcement officers require the driver as well as passenger in a vehicle to exit the vehicle when they are stopped on a traffic stop. And why do you think they do that? Well, there's a couple of reasons. For investigative purposes could be one. The second reason could be for safety reasons. But these are things that, again, that happen quite often. And a lot of times you'll see the officers actually set individuals on the curb and have them put their feet out in front of them. And again, that's a safety issue as well. But think about why they actually do that. Now, on one hand, this seems to interfere with the liberty of the individuals without reasonable suspicion that they pose a danger. But on the other hand, an officer should not be required to run the risk that a motorist or even the passenger has a firearm and basically to place the officer's life in jeopardy. So that can be one of the rationale that deals with this. Now, there's a case, Pennsylvania versus Mims, that the Supreme Court ruled that the legitimate interest in protecting the officer outweighed the what we call de minimis or minor intrusion of liberty. And it also affirmed the fact that officers can make the driver and passengers exit a stopped vehicle for the purpose of officer safety, providing that it's a minor intrusion. Okay, and that's the Pennsylvania versus Mims case. Now, some of the other issues that come up with this, because not all courts are kind of the same. 3 state Supreme Courts have refused to follow the Supreme Court and have held that the police require reasonable suspicion to order the driver out of a vehicle. 2 state Supreme Courts have held that an officer requires reasonable suspicion to order a passenger out of a vehicle. So there are other issues that kind of come up with this, right? So we have to kind of look at the fact that some of the courts are going to be a little bit different. And here is the legal equation as it relates to vehicles. All right, and finally frisks, and then we'll be done. The Supreme Court in Terry versus Ohio recognized that American criminals have a very long-standing tradition of armed violence, and that a number of law enforcement officers are killed and wounded every year in the line of duty. And most of these fatalities and injuries are inflicted at fairly close range with weapons like guns and knives. Therefore, the court accordingly ruled where nothing in the initial stages of the encounter serves to dispel an officer's reasonable fear for their safety. Therefore, they are entitled to the protection to protect themselves in the area, to conduct a carefully limited search of the outer clothing of such persons in an attempt to discover weapons which might be used to assault them. And again, you should keep some of the points that we're going to talk about here kind of in your mind. So again, we know the rationale for the frisk, It's intended to protect the officer. And a key factor is whether the suspect is reasonably believed to pose that threat. And courts have upheld frisks on some different types of factors. And very quickly, they would be things like a bulge in the pocket, or a suspect reaching into their pocket, or the suspect's furtive movements, if you will. The officer's knowledge that the suspect had been involved in some type of violent activity, the type of crime or violent activity, the suspect's presence in a high crime neighborhood, especially at night, and an individual being with another individual who was arrested by the police for a serious offense. Now, the officer need not be absolutely certain that an individual is armed and presently dangerous. Remember, the test is whether a reasonably prudent man or woman under the same circumstances would believe that his or her safety or the safety of others is in fact at risk. And several courts have approved kind of automatic frisks in the cases of suspected drug trafficking, because typically where there's guns, there's drugs. And so that's kind of one of the reasons for things like that. So what about a cooperative suspect? Well, a cooperative suspect who immediately offers a credible explanation and does not appear to pose a threat may basically eliminate, if you will, an officer's reasonable fear that a suspect is armed and presently danger. Now, despite the fact that the frisk does not automatically follow from the stop, it should be noted again that a number of courts have approved these, especially when you're talking about drug trafficking or dealing with gang members or guns, etc. Now, there are also some enforcement items, certain items that we use, that officers can use that do not violate the Terry stop. What about a flashlight? If I shine a flashlight at a person, does that violate the Terry stop, the Fourth Amendment? If I were to initially point my firearm at them because maybe they were made some kind of a movement or what have you, the mere brandishing of a firearm, does that violate the Fourth Amendment, the Terry stop? Or what about a drug dog? Think about those, and I'm going to let you stew on those, okay? But handcuffs, what about that? If I put you in handcuffs, is that a little bit more permanent? So you probably figured out the answer. So the first three are actually okay, and the last one, the handcuff, well, that presents a different issue as it relates to a Terry stop. So, automobiles. In the case of Michigan versus Long, the search must be limited to those areas in which a weapon may be placed or hidden. So you can search the area of a vehicle, but it has to be limited to those areas where a weapon may be placed or hidden. And of course, you're going to have to need probable cause. The same thing when it comes to narcotics. In a case, Minnesota versus Dickerson, narcotics can be seized as the result of a frisk. If they are immediately apparent and you develop probable cause, and that falls under the plain feel doctrine. So if I were to do a frisk and feel that hard gun in your pocket, even though I can't see it, I know what it feels like. That's the plain feel. The same thing for narcotics. Let's say heroin that's packaged in balloons like the bottom picture. If I'm an expert in narcotics, then I know what that feels like. And under the plain feel doctrine, I can seize those and the search will be upheld. And I thought I would just show you this pigeon drug courier because it was just extremely cool. And then we'll finish up with the legal equation as it relates to the Terry frisk. Okay, so with that being said, that's going to, I forgot we had the legal equation for drugs. Okay, So that's going to conclude the second half of our lecture for Chapter 4, Stop and Frisk. Don't forget to do the key terms assessment in the chapter module, and you can take that as many times as you want. And also, don't forget to look at the questions, the review questions at the end of the chapter. So again, that concludes our Chapter 4 lecture, and until next time.